Members, the sitting is resumed. It's time for questions to the Minister for Justice. Questions 12 and 14 have been withdrawn. I call Justin McNulty.
Question 1.
Minister.
In recent days, we have seen how the use of threatening and abusive words and materials targeted at those most vulnerable in society can spread fear and division in communities and incite hatred. I am continuing to prioritise actions to deliver support for victims of hate crime, including those targeted by hate expressions. The delivery of foundational hate crime legislation provisions in this mandate remains a key priority for DOJ. These provisions, delivered through a sentencing bill and a Victims and Witnesses of Crime bill, will modernise hate crime law in Northern Ireland and provide a more robust system to sanction offenders. In his review of hate crime legislation, Northern Ireland Judge Marrinan also recommended that there should be a clear and unambiguous statutory duty on relevant public authorities, including councils, the Department for Infrastructure and the Northern Ireland Housing Executive, to take all reasonable steps to remove hate expression from their own property and, where it engages their functions, broader public space. Policy development work on the removal of hate expressions is ongoing, including liaising with the named authorities in the recommendation, PSNI, local councils and DFI. As this work is complex and still ongoing, I do not intend to include Recommendation 15 provisions within the Justice Bill currently under consideration by the Committee.
Thank you, Minister. I call Justin McNulty for supplementary.
I thank the Minister for her answer. We saw a very positive example of this last number of weeks, where McLaughlin and Harvey were contracted to remove hate crime graffiti on bridges in the Newry area. Minister, adoption of Recommendation 15 would include a requirement that there should be a clear and unambiguous statutory duty on public authorities to take all reasonable steps to remove hate expression from their own property and broader public space. In other words, removal of material facilitating racist and sectarian intimidation from housing. Would you agree with me that this is a vital legislative step given recent attacks?
Well, first of all, I agree that it is vital that those hate expressions are removed from public display. I believe that them remaining in place normalises and makes acceptable expression of sentiments and violent thoughts that are not acceptable in a civilised society. And I think we need to acknowledge that. I think the issue here is about how we actually take this forward. You know that there was the Ficht Commission report, for example, which looked at the display of emblems and symbols in public spaces, and we were unable collectively as 5 parties to get agreement as to how that would be taken forward. What I want to do is look very specifically at the recommendations which have been brought forward by Judge Marrinan. However, given that it creates duties on local authorities that fall outside the purview of the Department of Justice, I will need the cooperation of other departments in the Executive to be able to bring that into effect.
Jonathan Buckley for supplementary.
Deputy Speaker. Minister, there are those in society who seek out offence even when no offence exists. One of your former Alliance Party colleagues on Causeway Coast and Glens called for the removal of a completely inoffensive biblical verse on a wall in Portstewart. Can the Minister give guarantees that, whether it be Recommendation 15 or other hate crime legislation, that it will not lead to the persecution of those of faith in public spaces or the development of a thought police at the expense of free speech?
Well, Madam Principal Deputy Speaker, there is of course a salty retort I can make about those who go seeking offence, but I'll set that aside and be more ministerial in my approach to the member's question. I'm, first of all, as the Speaker has already acknowledged, not here to answer questions on behalf of the Alliance Party, and the member already knows that. What I can say is, and I say this as a person of faith, there is nothing in my faith or any other faith that justifies the use of hateful language, of hateful expression, or of hateful behaviour. And I think that those who believe that their faith justifies such expression and behaviour need to reconnect with it.
Excuse me, Jonathan. Neil McAllister.
Minister for her answers, and I want to move on to some questions that the Minister can answer because it's within her department's portfolio and remit. At the heart of a lot of these assaults over the last few weeks are victims. I want to ask the Minister if you could outline a little bit more about the work your department has undertaken to support victims of hate crime.
Well, first of all, providing guidance and practical assistance in the aftermath of hate crimes offers vital support at a critical time. Enhanced protections for victims is available through a range of mechanisms. There is direct support provided through the Hate Crime Advocacy Service, which is jointly funded by DOJ and PSNI. That supports victims as they journey through the criminal justice process, signposts them to support services, and can assist with third-party reporting to the PSNI. DOJ, PSNI, NIHE and the Department for Communities also jointly fund the Hate Incident Practical Action Scheme, HIPA, which is there to provide personal and home protection measures if someone's home has been damaged or they have been the victim of hate crime at their home. And the Help in Hand app actually provides multilingual avatars to help support victims of hate crime in their own language and provide understanding on how the criminal justice system works. We also support the work of PCSPs, and their work includes raising of awareness and education initiatives on reducing hate crime in local communities and introducing legislative provisions, as you're aware, which will modernise race hate crime law in Northern Ireland as part of the sentencing bill and provide a more robust system to sanction offenders and improve support for victims of hate crime.
Thank you, Minister. I call Deirdre Harkey.
Minister, for your answer so far. Minister, there was an attack obviously on the Belfast Islamic Centre, and there was swift follow-up action with a person appeared in court yesterday. Can you also ensure that there will be swift follow-up responses and accountability to those that have carried out recent attacks across the north? Thank you.
Well, first of all, I would want to condemn the attack on the Islamic Centre in Belfast at weekend. It has caused distress and alarm, not only among those who were at prayer at the point when it happened, but also at those who use the centre regularly and other members of the community. We're committed to playing our part in DOJ in terms of trying to deliver a safer community for all, including victims of race hate crimes and Islamophobia, in partnership with other government bodies and beyond. I have been reassured by the Chief Constable that he intends to take swift and robust action when it comes to following up on those offences. I've also been reassured by PPS and by the courts that they do have the capacity to be able to do that, and I have said publicly that if more resources are required in order to expedite that, we are open to listen to those calls for additional support.
I call Cheryl Brownlee.
Question 2.
Significant support provision has already been made available under the 7-year Domestic and Sexual Abuse Strategy for 2024 to 2031, which my department leads in partnership with the Department of Health. The support and provision pillar of the strategy is intended to ensure that all victims of domestic and/or sexual abuse can access tailored, responsive and specialised support and provision to recover and build their lives. Support currently in place under the strategy includes the Sexual Offences Legal Advisor Pathway project, which provides victims of serious sexual offences with a wide range of legal advice and information up to the point of a trial, and which have extended from February to include a children's SOLA service. A domestic violence and abuse disclosure scheme aimed at protecting victims and future victims of domestic abuse, which includes a right to ask and a power to tell. The Assist NI Advocacy Service for high-risk victims of domestic abuse and victims of serious sexual offences, engaging with the justice system, and a bespoke children and young people service under the same auspices is due to commence on the 1st of July. There is a 24-hour domestic abuse helpline in Northern Ireland provided by Nexus, funded jointly by DOJ, DFC and DOH, and delivery of advocacy support services to families after domestic homicide of a family member or friend. However, it's important to acknowledge that domestic and sexual abuse is not just a justice or health issue, and a range of support has also been made available by other departments. As implementation of the strategy progresses, further action plans will be developed, building on earlier actions where necessary and developing new actions as appropriate.
Thank you, Minister. Called Cheryl Brownlee for a supplementary.
Thank you, and thank you, Minister. Breaches of non-molestation orders has been raised with me by a number of victims and survivors groups. So could you detail what steps are being taken to ensure victims are adequately protected following repeated breaches of the non-molestation orders?
Well, I would like to, but unfortunately non-molestation orders fall under the Department of Finance. However, it is an issue that we have raised in terms of the level of protection that those offer to people at the point where they have actually sought out a non-molestation order and then it's been breached. I mean, the breach of a non-molestation order is a criminal offence, and therefore a person can be taken to court for that. How that has progressed obviously is an operational matter for the court officials and also the judiciary and the police. However, from my perspective, what I want to ensure is that there are the proper protections in place to ensure that people have the wraparound services that they need. But on the issue of specifically of non-molestation orders, we have surfaced this with the Department of Finance to see if any reform of that system is required.
Call Connie Egan for supplementary.
Thank you, Minister. Could you please outline what action your department is taking to prevent the harmful and abusive behaviours that are linked to domestic abuse?
Well, the Department provides funding to Probation Board for Northern Ireland's Promoting Positive Relationships programme, and that's aimed at adult males who have demonstrated the potential to be abusive in intimate partner relationships and where children are assessed as at risk by social services. A key feature of that programme is the inclusion of a dedicated partner support worker who provides support to the current partner of the participant, and it's delivered across all 5 trust areas. In addition, we've recently approved a significant increase in investment in the programme, which will allow the number of programmes delivered annually to rise from 60 to 90, and that will help with intervention and support. As part of the new DSA strategy, the Department will also be undertaking work to look at costed options to enhance measures to address abusive behaviours. We also work hard to tackle the toxic masculinity and misogynistic ideologies that are so closely linked to domestic violence and cannot be achieved by DOJ alone. TEO, as the departmental lead for VOG, for example, has an important role to play, as does the UK Government, which holds a reserve power to regulate online environments where these ideologies are often spread.
Call Cara Ferguson for supplementary.
Thank you, Principal Deputy Speaker. Minister, what more do you feel can be done by the Department to raise awareness of legal aid waivers for domestic violence protection? Thank you.
Well, there are a couple of things. First of all, I'm aware that a number of people who have approached their solicitor to ask about the waiver for legal aid in domestic violence cases have either been advised that that wasn't available or have been sent down a different track. So we have first of all engaged with the Law Society, and we've asked them to provide more information on that to their practitioners so that they're fully aware of the option of the waiver. The second issue is the feedback that we've received from the legal profession itself, which has said that obtaining the waiver in itself can be quite a tricky process and quite engaged, and therefore we're looking at how we can simplify that process to make it more accessible for practitioners and ultimately for their clients.
Call Philip Brett.
Deputy Speaker, and can I thank the Minister for her answers so far. Could the Minister outline any discussions that she's had with the Minister for Communities about the ongoing review of the Housing Executive's Common Selection Scheme to ensure that victims of domestic violence are properly reflected in the new points system?
It's one of the issues that I raised when I responded as a member of the Executive to the paper that came to Executive about the review of the Housing Priority Scheme. I think it's really important that in a society which is changing and developing rapidly, that we do look at the equity in terms of victims of domestic and sexual violence and abuse in terms of how they're treated in the housing waiting list. There are some schemes already available. So there are schemes available, for example, to provide more security where a family has been particularly targeted in their home by domestic violence and abuse, and where they're able then to ask the partner to leave as opposed to the family having to leave, which is so often the case. And I think making people more aware of those schemes would be one thing that we could jointly do. But I also do welcome the fact that it is the intention of the Communities Minister to give priority to domestic violence and abuse victims, because often where to go is the biggest fear that people have as they leave their home. And I think the tendency is for people simply to see it as a house. But it's not, it's a home, it's something that they've invested in for many years, and I have to say that my preference would be that the perpetrators were removed, not the victims.
Thank you, Minister. I call Diane Forsyth.
Please.
Existing arrangements are in place under PSNI Child Protection Disclosure Scheme, allowing information to be disclosed to members of the public where it is necessary to protect a child or children from serious harm. Such information may be requested by any member of the public and will be disclosed by the police where it is appropriate to do so. Police or other agencies may also proactively disclose information in relation to serious offenders where it is necessary to protect victims, potential victims or other persons in the community. These mechanisms are in line with the disclosure requirements set out in Article 50 of the Criminal Justice Northern Ireland Order 2008 and with the statutory guidance which my department has issued to agencies involved in the public protection arrangements in Northern Ireland. I consider that these arrangements are consistent with child safeguarding requirements. I would encourage anyone who is concerned about an individual posing a risk of harm to children to contact police in the first instance to seek that disclosure.
Thank you. I call Diane Forsyth for supplementary.
Thank you, Madam Principal Deputy Speaker, and thank you, Minister. Minister, I have had a couple of cases recently within my constituency where people have been moved and housed, and it has come out some way later on that in fact there's a a child sex offender living within the park, much to the alarm of the local residents. Are you suggesting that it should be the case that whenever somebody new moves into a particular estate where children are, that the local residents should be seeking information about every individual that moves into the area in the interest of safeguarding their children?
Minister.
Well, that's not what I'm suggesting. What I'm suggesting is that where there is a risk and where the police deem it to be proportionate, they will notify local families if there is an issue. Child safeguarding is the priority here. And so the police and other agencies can proactively disclose information about offenders, but that has to be proportionate, and it's critical the criminal justice agencies operate lawfully. There is already case law in this regard, and it has determined that disclosure must be proportionate to the risk posed, necessary for public protection, and in accordance with the law. So automatic disclosure in all cases is unlikely to be lawful. That's in line with the approach in other parts of the UK and in the Republic of Ireland. It could also lead to members of the public being wrongly identified as sex offenders because there are rules around what information can be disclosed. The important thing from my perspective is that if anyone is concerned about an individual who is behaving at all inappropriately or suspiciously around children, they should report that to the police and seek disclosure in respect of any history that individual might have.
Thank you, Minister. I call Stuart Dixon for supplementary.
Thank you very much, Principal Deputy Speaker. Thank you, Minister, for your answers so far. Minister, may I ask you just to outline broadly the action that your department is taking to address sexual-related offending?
Well, there are a number of work streams that we are trying to progress which will address sexual offending and the harm that it causes. I've already strengthened the law in this area under the Sexual Offences and Trafficking Victims Act, where we included new offences of upskirting, downblousing, cyberflashing, pretending to be a child for the purposes of child grooming, and a number of others. I'm also proposing to strengthen the law further with the extension of a number of provisions of the UK Crime and Policing Bill. And as you'll be aware, the first of two intended LCMs was agreed by this House yesterday. That includes strengthening and streamlining the sex offender notification requirements, because of course it is important that the authorities know where a sex offender is. It also looks at those who wish to change their name as sex offenders and the notification requirements for them to be able to do so, and also for them to be able to get a replacement identity in a new name. It also then brings up the paedophile manual into line with modern technology and deals with AI-generated images. So those are a number of areas, and also at consideration stage of the current Justice Bill, I'm hoping to bring forward amendments which we're due to take out for consultation shortly on deepfake image offences. Unfortunately, the opportunity to do that via a Westminster Bill was changed because the particular clauses were removed from the Crime and Policing Bill by the Government on foot of another private member's bill being brought forward. So we're going to do this with the consent of the committee through the consideration stage of the bill. So there is significant work happening. There is also a public protection arrangements and MARAC review which we're looking at. So I think there is good work being done, but of course we are always keeping a watch and brief on what is a very serious issue.
Thank you, Minister. I call Cara Hunter for supplementary.
Principal Deputy Speaker, and I thank the member for bringing this important question forward. Many parents and families in my constituency care deeply about transparency around sex offenders in their community and around their children. Minister, can you please update the House on your assessment of the use of castration of known paedophiles who have been through our justice system and are now in our communities who have caused harm to minors and children? Thank you.
Well, there is no provision in Northern Ireland law for the chemical castration, I'm presuming the member means, when it comes to sex offenders. But obviously you're aware that this is an issue that was raised as part of the sentencing review which was undertaken in GB for England and Wales. What it actually asked was that the government would look in more detail at the evidence base for that. So there are competing arguments in favour and against, not just in the human rights space, because of course this is only referring to voluntary chemical castration. There's no prospect of involuntary chemical castration, but there has been expressed significant concerns that the reliance on chemical castration can lead to situations where the level of supervision of an individual is reduced and that the harm has not been adequately addressed. So I think that's something that we will want to keep a watch and brief on, see what is happening in England and Wales in terms of the building the evidence base place, but also then review what we do. However, what I would want to say is that the monitoring of sexual offenders, whilst it is complex, is robust. We do have a series of different issues, whether that is licence conditions, whether that is notification requirements, whether that is the monitoring of people on the sex offenders register, whether it is PANI arrangements. There are a number of agencies and organisations that work hard to ensure that those sex offenders who return to the community are properly monitored and that their behaviours are closely watched. And as I say, where anyone, and I think that this is the key if you want to protect your children, is you can't simply rely on the fact that somebody has previously offended as an indicator or that they're a known offender. There are many people who have been offenders for many years who live amongst us and are trustworthy to all intents and purposes, and yet it emerges much later that they are sex offenders. So the key for parents is to be guarded around all adults.
Linda Dillon for supplementary.
I'd like to thank the Minister for her answers so far, and you've actually just touched to the point that I want to raise. What can we do, I think, and not just with your own department but also with the Education Minister, in terms of raising that awareness? There was a programme called the Pants Talk, which was absolutely excellent. What can we do more in that space so that parents and young people and children understand that actually the greatest risk is from those who have access to you and who have the trust of your family? Because we need to stop worrying about strangers, start worrying about the people that are in our homes and around us.
Thank you.
Well, I mean, I totally agree with what the member says. I mean, the evidence is, I mean, I think we were all raised on a diet of stranger danger, where we were told that the people who we had to be afraid of lurked in parks wearing masks. And the truth is, they didn't. They lived amongst us. And if you look at the history of sexual abuse, they were people in the clergy, they were people who had access to children through organisations that were respected. They were family. And trusted individuals and friends. So I think we also need to be careful about getting that balance right, because the majority of young people who are abused will be abused by somebody known to the family, and that is the reality of the situation. And the stranger danger part, whilst we should never diminish it, is not the main threat. What I do think is important is that through education, and this is where I suppose I believe that age-appropriate, non-judgmental RSE is hugely important, because these are exactly the kind of conversations that we need to start having with our young people. We need to tell them what is appropriate, what is not appropriate. We need to give them the agency to say if they're uncomfortable with touch or if they're uncomfortable with how somebody behaves toward them, and to have the opportunity also in lessons of that nature to be able to make disclosure if indeed they have been so unfortunate as to have been abused.
I call Sean Mulholland.
Forward, please. The current law in Northern Ireland on the physical punishment of children is based on the concept of reasonable chastisement. Article 2 of the Law Reform Miscellaneous Provisions, Northern Ireland Order 2006, has the effect of restricting the grounds on which the defence of reasonable chastisement can be used. In essence, this means if a parent or adult smacks a child and is prosecuted, they can defend themselves in terms of reasonable chastisement, but only if the harm is minor. Anything which causes more than transitory or minor discomfort is unlawful and can result in prosecution. Consequently, a mild smack is therefore still legal in Northern Ireland. I met with the Royal College of Paediatrics and Child Health, who published a report in 2004 on the impact of physical punishment on children and young people. The report found that the use of physical punishment has a negative impact on children's physical and mental health, as well as their social, emotional and behavioural outcomes. It also raised concerns that identifying abuse became a more subjective process for professionals, allowing abusers to hide behind this defence. This is why I am fully supportive of changing the law here in Northern Ireland. However, the issues are broader than criminal justice alone, and any change to the law would require executive agreement. Despite my best efforts and support from expert stakeholders, including Northern Ireland's Children's Commissioner, I have not been able to secure executive agreement needed to deliver a change in the law in this area in the current Justice Bill. However, I will continue to try to seek the support of my ministerial colleagues to repeal the defence of reasonable chastisement here in Northern Ireland and move towards a position of equal protection.
Call Sean Mulholland for a supplementary.
Thank you so much. Minister, would it be possible for you to outline the legislative context in which other jurisdictions in GB and Ireland operate in, and how children are protected there?
Well, children in Scotland, Wales and the Republic of Ireland have equal protection from assault, as do adults. So the Children Equal Protection from Assault Scotland Act in 2019 removed the common law defence of reasonable chastisement from the law of Scotland on the 7th of November 2020, and it was commenced 12 months later. The Welsh Government's Children Abolition of Defence of Reasonable Punishment Wales Act 2020 came into force on the 21st of March 2022. A comprehensive multimedia stakeholder and public awareness campaign was completed before commencement. A 3-year interim review will provide a post-implementation report due to be led before the end of this year. Campaigners for children's rights are still waiting for equivalent legislation in England and Northern Ireland, leading to an uneven picture for child protection across the UK. On the 11th of November 2015, the Irish Parliament adopted legislation explicitly repealing the common law defence of reasonable chastisement of children. That came into force on the 11th of December 2015.
Call David Brooks.
Principal Deputy Speaker, question 5.
While the Minister of Finance and I have approved the PSNI Workforce Recovery Business Case, affordability remains a key concern given the current pressures on public finances. I've heard the comments made by the First Minister and would like to see this funding prioritised. I had a constructive meeting then with the Finance Minister about the business case this morning, and it will ultimately be for him to bring this to the Executive for approval. This funding could be a game changer in ensuring we can grow officer numbers and put the PSNI on a sustainable footing. Every party in the Assembly has acknowledged that the PSNI is not adequately staffed, so now is the time to support funding for that business case.
David Brooks for supplementary.
Thank you, and I thank the Minister for her answer. Our party, of course, is supportive of this work and was among the first to push for it. Given our meeting with the Finance Minister, can she provide any insight into which departments may be asked to provide resource for it?
Well, as things stand at the minute, just to provide some clarity, PSNI have set aside a provisional £7 million this year for recruitment in the first year, which is the first year of the business plan. However, that adds to their pressures because it hasn't been as yet funded by the Executive. Those pressures at the minute are around £21 million. So 7 of that is for the business case for recruitment. So even if they were to get the 7 million, we would have to find a way of bridging the gap on the remaining 14 for it to be affordable. But the Chief Constable has agreed to go away and do a piece of work on that. Next year it would cost about 26 million. So the hope would be that when we come to set a 3-year budget, we would look at the 3 years from the point where that budget will kick in, and we would make an allocation in each of those 3 years, which would then allow us to ensure that the PSNI rises to the 7,000 officers and roughly 2,500 staff, and then also is maintained at that post reaching that after 3 years. But we're still working through that, so allocations in this year would definitely be very welcome in terms of starting the process, but we do need that longer term horizon in order to make it work.
David Honeyford for supplementary.
Thank you, Principal Deputy Speaker, and thank you, Minister, for your response so far. Could you outline the steps that you have taken to prioritise resourcing of the PSNI within the current budgetary environment?
Look, I've taken every opportunity to do this. I mean, first of all, in the opening budget allocations, and also as we have gone through the year to date, which in fairness in this year is only about 10 weeks in. So if we look at the PSNI, 65% of the funding that came into the Department of Justice went to PSNI, and 35% provides the entire remainder of the system. So that gives you some idea of the proportion, the proportional split. We have to run everything else, courts, probation, everything, prisons, on the basis of 35% of the remaining budget. We also know that there are other challenges, so we got an additional 5 million towards making our community safer, which was one of the priorities in the Executive programme, and the PSNI will receive 4.75 million of that, which is 95% of it. In addition to the baseline allocation, we also had additional executive allocations of 132.3 million, and PSNI received just over 86 million of that. So I think from my perspective, there has been a prioritisation when it comes to the PSNI. Sadly, they also, I should say, got 3.3 million towards the increased cost of employer national insurance contributions. I also submitted a bid in light of the recent riots for £5 million to help the PSNI with the additional cost of mutual aid. However, it is sad that that £5 million has gone essentially in supporting the policing of riots when it could have gone directly into increasing the number of officers available to do general policing.
Thank you, Minister. I call Matthew O'Toole for a supplementary.
Thank you, Deputy Speaker. A very quick one. I hope we will hear that this business plan will be met later this year, because some of the words from the First Minister indicated that they would. But can I ask, when that workforce plan is published, will it address what now appears to be a crisis in Catholic recruitment to the PSNI numbers are at an all-time low? I don't want to necessarily get into all of the old categories, but we do need to rescue Catholic levels of recruitment. Does the Minister agree?
60 seconds.
I think it's very important that our police service is representative, and I look forward to working with the member to ensure that it is so going forward.
Thank you, Minister. That ends the period for listed questions. We'll now move on to 15 minutes of topical questions, and I call Justin McNulty.
Last week, a headline in the Belfast Telegraph reported that a lot of young people believe they missed out on the Troubles. Minister, many of us grew up with and were shaped by the violence, the maiming, the murder, the fear and the terror of the Troubles. So how is it that young people today, born after the peace process, are coming to the view the horrendous violence and the devastation of the Troubles that still haunts and scars people to this day as something they missed out on? And what measures are being taken to address the underlying causes of youth disengagement and susceptibility to paramilitary propaganda and influence?
Minister.
Well, I'll answer the first part of that question as best I can, though it isn't necessarily one for the Department of Justice alone. I think there are a number of factors. I think, first of all, the lack of lived experience, that people see stuff on television and they think it looks exciting. And if you've never actually been fearful for your life in the way that the people who lived at interfaces when riots were taking place, in the way that they felt, then you're not going to recognise the potential risks. Young people, because of the stage of their development, are often risk takers. They often don't see long-term consequences in the same way as we do as adults, and therefore I think that there is a tendency for them to engage in high-risk behaviours, and that obviously is challenging. I think there are also those who are subject to criminal coercive control within communities, and I think that there has been, both online and in communities, a degree of indoctrination and radicalisation of young people to think it's exciting. But I would also say this very gently to members in this chamber: if we glorify and put people on a pedestal as heroes because of things they did during what was a horrendous period, there is a risk that young people, instead of looking up to those who were law-abiding throughout and who adhered to the normal rules in society, will see that those are people they should emulate. And we have to be conscious as we work through how we respect those who have passed, and at the same time don't glorify situations or behaviours that could endanger another generation of young people.
Justin McNulty for supplementary.
So would the Minister therefore share my concerns that the executive that your party occupies, that supposedly aims to stop paramilitarism, is led by a party that uses propaganda on illegal billboards, on social media, and uses every channel possible to glorify the IRA violence and bloodletting, and who are allied with unionist leadership who are soft on the erection of UDF flags and paraphernalia, and thereby collaborating to perpetuate a sectarian hate divide across our community?
It's questions, Justin, not speeches. Minister, please.
Well, I think my initial answer makes clear my views when it comes to paramilitarism. I have been consistent throughout my political career that there can be no place in our society for paramilitarism. And whilst I respect the right of every community to respect their dead and to commemorate those matters that are important to them, I think we all need to be conscious of the impact and influence that that can have on young people and what they see as how to be a champion or a hero in your community. Let's create the positive role models that young people want to emulate, who are able to do things without ending up spending considerable lengths of time in jail.
Thank you, Minister. Call Philip Brett.
Minister, you'll be aware of the campaign that's been launched by the Police Federation for Northern Ireland, Let Them Protect. Would the Minister join with me in giving her full support to that campaign to ensure our brave police officers right across Northern Ireland get the protections that they deserve?
Minister.
More than happy to do so. I was at the launch of the Let Them Protect campaign, and I think anyone who has seen the very hard-hitting advertising on television will be struck by the vulnerability of the people who the police are attending to day and daily, and the risks to those people if PSNI officers are instead in hospital waiting rooms seeking treatment for assault. It is not acceptable that when people run towards harm to protect us, that they end up being spat on, bit, kicked, having masonry dropped on their heads, and a whole host of other abuses, their cars rammed and other things. When people step forward to protect this community, they deserve to have the respect of this community and its cooperation. And for those who attack the PSNI, they are not just attacking the PSNI. They are attacking, first of all, people who are members of families and communities themselves and whose families are distressed by what happens, but they're also attacking the wider community because they're preventing the police from attending to those crisis situations and they're delaying them in their response. And that could cost any of us. That could cost any of us if we ever need to dial 999 in an emergency. One of the things I want to do as part of the sentencing bill that I'm bringing forward in the autumn is to increase the aggravator that applies to assault, to take account of anyone who is providing a public service or a service to the public or working in front line, so that that can be taken into account in sentencing. Because to be clear, if somebody is there serving the public, they should be able to do it without fear or threat of intimidation or violence or assault.
Philip Brett for supplementary.
Thank you, Madam Principal Deputy Speaker, and can I thank the Minister for her strong words on that, and can I also thank her for agreeing to meet with me next week to discuss the possibility of introducing Harper's Law here in Northern Ireland. In advance of that meeting next Tuesday, Minister, will you consider bringing an amendment to your forthcoming sentencing bill which will ensure that anyone who tries to murder our police officers receive the life sentence that they deserve?
Minister.
Well, look, the member will know what I've said before about not wanting to encroach on judicial discretion when it comes to particular situations, and I am conscious of the risks around prescribing particular sentencing outcomes that would then apply in every case. But I'm open to discussing with the member how we can make sure that there is a deterrent effect, because unlike many of the other spontaneous crimes that we talk about, where deterrent really doesn't play a role in people's decision making, people made choices over the last number of weeks. They chose to go to places where riots were happening. They chose to promote those riots on social media. They chose to come armed with Molotov cocktails and large pieces of masonry, and they chose to attack police officers. When you make those choices, that should be reflected in sentencing.
Andy Allen.
Speaker, in addition to statutory delivery such as the Youth Justice Agency, can I ask the Minister for her assessment of the role of community-based restorative justice?
Minister.
Well, with respect to restorative justice, the member will be aware that this is something which I do feel quite passionately about. I believe that, as I said yesterday, one of the purposes of sentencing is to ensure that reparations are made to the community and that people are forced to confront the impact of the harm that they've caused as they offend. And part of that, I believe, can be done through the restorative practice. As you'll be aware, we are doing quite a bit of work in the restorative space in terms of setting up for accreditation, both of groups and specifically of individuals who can operate at different tiers, whether that's at the community level, in terms of restorative practice to diffuse community level tensions, or whether it is at the highest specialisation level of, for example, restorative practice in some serious crime like murder and rape. And obviously those are much more complex and require much more skilled and educated practitioners and more experienced practitioners, but it is something that we're passionate about moving forward with.
Thank you, Minister. Andy Allen for supplementary.
Can I thank the Minister for her answer? And Minister, can you perhaps advise what engagement you've had with community-based restorative justice organisations to help inform that view and indeed the role that they have moving forward?
Minister? Yes, there's a conference which happens by the restorative, I think it's the Restorative Justice Committee, which is a national organisation. They have their annual conference here, and they had it just earlier this year, and I was at that and attended and spoke at that. And I also regularly meet with restorative practitioners, whether they're working in probation, whether they're working in prisons, or whether they're working in the community and voluntary sector.
Thank you, Minister. I call Jerry Carroll.
Minister, there's been some £200 million touted in new money for the PSNI. Do you believe conditions should be put on this money, including to reduce stopping searches and stop the use of plastic, rubber, AEPs, amongst other inhumane practices?
Minister.
Well, I think the first thing to say is that plastic bullets have not been used in Northern Ireland for a very long time, and the current AEPs that are used are of a different magnitude and a different make, and they're not used in a liberal fashion. So they're only used when there is a threat to life, and the alternative to using them would be to use live rounds. So I think we have to be careful to leave it with the PSNI to make those calls in terms of how they police those situations, and to the policing board to scrutinise the use of those different tactics as it comes along. In terms of the use of stop and search, I am aware of issues with stop and search. There's been much research done into this and also much feedback that we have received, particularly from those who feel particularly targeted by it. But I do not believe that it would be appropriate to tie the PSNI's hands beyond what is required by the Policing Board in terms of appropriateness of their responses. Again, it would not be appropriate to put conditions on the resourcing and to link those in some way to making political points about how the police go about their operational duties. I've always been clear, the operational duties for the police are the responsibility of the Chief Constable. He is answerable to the Policing Board for those.
Jerry Carroll for supplementary.
Thank you. And I just remind the Minister that rubber bullets and AEPs are deadly and dangerous and are being used. I'm disappointed by the answer from the Minister, but how confident, Minister, are you that the new money used won't be used to continue the use of stop and search and the further use of lethal plastic and rubber bullets? And on your website it says your responsibility is to support access to justice and support victims of crime. I think the people involved targeted by these two categories meet that category.
Minister.
Well, first of all, to clarify, I didn't say that AEPs weren't, that couldn't be fatal, because there are circumstances in which they will be, but they are less fatal than the alternative, which is live rounds. That is the point that I made. So I didn't say AEPs because I know that tragically people have lost their lives because they have been hit by a plastic bullet, but these are the plastic bullets are no longer deployed. It's AEPs that are now used, and they are a different category of ammunition, but they are still ammunition. To be clear, when you throw a petrol bomb at a police officer, though, I mean, that is an assault on that police officer's life. And if a police officer's life is under threat anywhere else, they would resort to live rounds. So, you know, I'm not going to get into a situation where I try to dictate to the police how they go about their job. As I've said, that's a matter for the Chief Constable, and he is accountable to the Policing Board. I am aware, however, that the Policing Board are looking very carefully at the issues around powers of stop and search and how those are used to ensure that there are robust safeguards in place, because of course the human rights of us all as citizens matter, and police powers have to be fettered within the law, and therefore that is something that the Policing Board are doing. But I don't believe that that is something that should be tied to what is a basic resourcing issue. We do not have enough police officers, and with respect, if we had more police officers engaged in more direct community policing, we may not have young people on our streets placing themselves in danger.
I call Andrew McMurray.
Thank you, Principal Deputy Speaker. Thank you to the Minister. Minister, could you outline your department's proposals for increasing maximum sentences for those found guilty of causing death or serious harm of a child or vulnerable adult?
Minister.
Well, Madam Deputy Speaker, we're looking at proposals at the minute at the offence of causing or allowing the death or serious physical harm of a child or vulnerable adult. The offence addresses cases where it's clear a child or vulnerable adult has suffered serious harm or death, but it is impossible to prove which household member was directly responsible for that. The offence could also be used where one person caused the death or serious harm and another allowed it by failing to act to prevent it when they had a duty to protect the victim from harm. In such cases, both of the perpetrators could be charged under this law. The maximum sentence currently in Northern Ireland is 14 years for cases involving death and 10 years for serious harm, but in England and Wales they were increased in 2022 to life for causing death and 14 years for serious harm. And so we are consulting at the moment as to whether the views here with regard to sentences in Northern Ireland are adequate, or whether they should also be increased in line with those in England and Wales. And we are also inviting opinions on whether we should adopt a similar approach to that in England and Wales with the aim of consistency across jurisdictions. What we want to ensure is that the courts have the maximum flexibility when it comes to applying sentences in what are horrific cases.
I call Andrew McMurray for supplementary.
Thank you, Minister. And just could I follow up by asking the Minister what her assessment would be of the difference these proposed changes would make?
Increasing the maximum sentence for the offence, the courts would be empowered to reflect the full gravity of cases where a child or a vulnerable adult has suffered death or serious harm, where there's been a willful failure to act to protect that person. I think that sends a very strong message about the seriousness with which we all view such failures, and strengthens the principle of accountability within households and caregiving environments. It also, I hope, reassures the public that the justice system is capable of imposing proportionate penalties in what are tragic and sensitive cases. In practical terms, it would allow the court to differentiate between lower-level neglect and much more significant conduct, such as prolonged inaction in the face of obvious risk. I think we will all have been horrified at some of the cases that we have seen over recent years where children and vulnerable adults have clearly been abused over a protracted period of time, and yet astonishingly no one in the household took the time to report that neglect or abuse. That's what we want to drive out.
Maurice Bradley for question.
Thank you very much, Principal Deputy Speaker. Minister, over 60 PSN officers have been injured throughout the recent disorder in Ballymena, Larne and Portadown, including naked sectarian attacks in Londonderry directed at residents in the Fountain. What financial help is your department giving to the PSNI to improve community engagement and build public confidence in areas affected by this disorder?
Minister, you've less than a minute.
Well, I think in the first instance what we're doing is providing them with the money that allowed them to build resilience by getting mutual aid, and that's around £5 million, and we're very hopeful of that coming through. In terms of the wider resources available to the PSNI, I think the best way for the PSNI to build confidence in communities is to be in those communities, policing them at neighbourhood level, and that's why I've put forward the business case, and I'm hopeful that the Executive will buy into that business case very soon.
Thank you, Minister. Regrettably, Maurice, there's no time, so time's up for questions to the Minister for Justice. We move on to questions to the Assembly Commission. Just to inform you all that questions 6, 9 and 15 have been withdrawn.